Welcome everybody to our first in our series of 2 webinars marking the 15th anniversary of Hurricane Katrina and looking at how crisis affects the criminal justice system. Before we begin, Eric, I think you'll all be able to hear you, but can you just say something to confirm?
Hi, Malia.
Thank you. Perfect. So this webinar will look at incarceration from Katrina to COVID. It is sponsored by the ABA Standing Committee on Legal Aid and Indigent Defendants, co-sponsored by the Decent Criminal Law Reform Center at SMU Law School, the ABA section on civil rights and social justice, and the ABA criminal justice section. During today's program, I'm going to encourage everyone to ask questions of our panelists. There'll be time at the end to address them. As an attendee, you should see a control panel on the bottom of your screen with a little spot called Q&A. If you can, please submit your questions through Q&A rather than chat. That would be helpful to me as moderator. We'll be sharing a recording of this program to everyone who's registered. You're welcome to share it widely with your networks. We're also going to be posting it on the ABA SCLAID website. Please feel free to leave us feedback or ask questions and follow up. And with that, we're thrilled to bring you today's program titled Left to Die, Incarceration from Katrina to COVID. Briefly, our panelists today are Meg Garvey, who's a public defender at the New Orleans Public Defender Office, Brendon Woods, who is the Chief Public Defender in Alameda County, California, which is Oakland, and Eric Balaban, who's joining us by phone today due to an insecure internet connection. He is Senior Attorney at the ACLU National Prison Project. We are also joined today by the ABA's immediate past president, Judy Martinez. As a private attorney, Judy has received a number of awards for her pro bono efforts to improve the criminal justice system and access to justice more generally. As a longtime resident of Louisiana, this topic is particularly close to her heart. So, Judy?
Thank you, Malia, and thanks to all of you. I'm honored to join you today for this important discussion on incarceration and the parallels between the eras of Katrina and COVID. And thanks to the ABA Standing Committee on Legal Aid and Indigent Defense and its chair, Ted Howard, for hosting the webinar, and to the section of criminal justice and civil rights and social justice and the Decent Criminal Justice Reform Center at Southern University Dedman School of Law for their co-sponsorship and their support. Even before the pandemic, I knew firsthand the life-altering impact a disaster can have, especially in my own town, where what we have known over the years and decades is that it can destroy what one holds dear. New Orleans, my hometown, was devastated by Katrina, of course, 15 years ago, and I've watched as countless hurricanes and floods and tornadoes and fires have impacted so many across the nation since that time. And New Orleans once again was in peril, becoming a real hot spot for coronavirus, which has plagued our nation in so many places. This pandemic was similar to Katrina, and as most crises tend to do, it's highlighting, as we go through it, the challenges and vulnerabilities and crises and opportunities within the federal, state, local prison systems and detention systems. And the ABA has long spoken out on these issues and contributed the expertise of its professional staff, such as Malia Brink and Jason Vale and Shubhangi DeHoris and Kevin Scruggs and Linda Britton and Paula Shapiro, and its extraordinary volunteer leaders. And it is in collaboration with local, state, and specialty bars and leaders on the ground that we, the ABA, often do our best work in small towns, in rural areas, and in big urban centers. But we must do more, and we must call upon our impatience and our sense of what we know is right and just as time is ticking away on the lives of the forgotten who remain behind bars. And that is what one of the goals was for some, wasn't it? And locking up and locking away so many for little reason and for so long, so that we'd forget about them. Well, we will not forget about them because of all of you and your dedicated service to the incarcerated. So thanks to all of our speakers who've gathered today and to our participants for joining us for what I know will be an invaluable discussion that'll look back on the time of Katrina and look now at what's happening during COVID. I look forward to the insights and the expertise of this exceptional panel And with that, I hand it over and back to our moderator, Malia Brink. Thanks, Malia.
Thank you, Judy. So before we begin, today's program is about individuals in prison during times of crisis. And our goal is not to focus as much on the tragedy, but rather to look at legal efforts to obtain assistance and release, and look at the reform that can come out of tragedy, what works, what doesn't, as well as what times of tragedy might tell us about how to focus or achieve prison and jail reform in the future. But before we hear from the lawyers, we thought it important to hear the words of those incarcerated individuals. For this reason, and in a start to what we hope will be a much larger effort, we asked two individuals to read excerpts of writings from such individuals. First, you're going to hear from someone who was in Orleans Parish Prison before and during Katrina. His letter will be read by ABA SCLADE Chair Ted Howard. And then in the second part, you'll hear the words written in an affidavit of someone in a Georgia jail cell during COVID, read by Sarah Tatanchi, the executive director of the Southern Center for Human Rights, which is endeavoring to get him out. Just a fair warning before I share my screen, the first reading is a little soft, so I encourage you to turn up your volume to the extent that you can comfortably to hear it.
I was abandoned in a cell for 5 days with no food, water, or ventilation. I watched other inmates suffer from disorders because they were not able to receive their medicine. I also witnessed inmates being physically assaulted by other inmates because some inmates were running loose, rioting and breaking everything. After my 5-day ordeal and 39 other inmates who were locked in their cells were let out by a maintenance man that works for the sheriff department, we were released from our cells. We were taken out of the building in two groups. On the first floor, we were met by water up to our chest. We were loaded on a boat, 10 at a time, while others waited in the water. We were taken to a nearby bridge. We sat there for about 2 to 3 hours. Then we were transferred by bus to Hunt Correction Center. We were placed on the ground of the inmates that was housed there and given water with 2 peanut butter and jelly sandwiches. 2 to 4 hours after we arrived at Hunt, me and more than 4,000 other hurricane victim inmates from Orleans Parish Prison were moved from the living quarter ground to the Hunt Yard football field just when it started raining. We were there in the rain for hours in that open field with no shelter, no toilet. The ground was so wet we couldn't sit down. Armed guards from the Department of Corrections at Hunt were placed outside the fence. During the 4 days I stood on that yard, I witnessed stabbings, assaults, fights, gang fights. The deputies who were outside the gate guarding us saw everything that was going on in the yard, but they did nothing to stop it. People's lives were in danger, and the deputies just stood outside the gate, sitting and watching. People's lives were in danger. My life was in danger. We should have been protected. We should have been out of harm's way.
This is a declaration of Barry Watkins. He is a client of the Southern Center for Human Rights in a case challenging COVID conditions in a Georgia jail. I am a 60-year-old man incarcerated at the Clayton County Jail, awaiting trial. My bail is set at $5,500. Each cell here is around 7 feet by 11 feet and contains a bunk bed, a toilet, and a sink. It has space for 2 people, but we have 3 in our cell. On a typical day, almost every one of the cells in my dorm had 3 people in the cell. The 3rd person sleeps on the floor next to the toilet. When I first arrived at the jail, we got 4 hours a day out of cell time. Since March, however, we only get about 60 to 90 minutes per day. We have this small amount of time every day to fit in tasks like showering, using the kiosk, and making telephone calls to our loved ones. On a typical day, I spend nearly 23 hours inside my cell. In 21 months at this jail, I have never been allowed out in the yard. We get meals twice a day. The first meal is brought to us in our cells at about 4 o'clock a.m. Around 9:30 to 11 o'clock a.m., we can exit our cells to receive our second meal. We pick up our lunch tray along with a dinner consisting of a sandwich bag and potato chips. There is no way to retrieve your food while maintaining social distancing, and jail staff is making no effort to encourage or allow us to maintain distance. We have limited access to personal hygiene items. Each week we are given 2 rolls of toilet paper, a small tube of toothpaste, and a 4-ounce bottle of liquid jail soap. We use this jail soap to wash our hands, to wash our bodies and hair in the shower, to wash our clothes, and to clean our cell. 4 ounces does not last any of us for a whole week. Our clothes are unclean. I have not received a clean jail-issued jumpsuit in 1 week. Sometimes it can take 2 weeks to get a jumpsuit. My underclothes have not been taken to be laundered in over a month. Our sheets are rarely cleaned, and when they are cleaned, we do not receive replacement sheets for long periods of time. My dorm mates and I must often sleep directly on the mattress for over 2 weeks because we have no sheets. The jail rarely launders our towels and washcloths. In the 21 months I've been at the jail, my towel has never been laundered. Those of us with working toilets wash our towels and underclothes in the toilet. The only thing we can use to clean ourselves is our towel or spare bits of toilet paper. If I use my towel to clean, I have to wash it in the toilet and dry it off before my next shower. In March, I began hearing about the COVID-19 pandemic from my adult children by telephone. Officers in the jail have given us no information at all about COVID-19 and its symptoms. The only piece of information I have received from the jail staff about COVID-19 was when they told me I need to put a towel or a sheet over my face in order to go to the jail's medical wing. Until recently, nobody in my dorm had a real mask. I used a makeshift mask made of a pair of boxer briefs. At the end of May, I was given a blue surgical mask. That mask has not been cleaned or replaced. About 1 month ago, I became extremely sick. I had a fever, a cough, diarrhea, and aches all over my body. I could barely move and I couldn't eat. I relied heavily on my cellmate for assistance. I was sick for nearly 2 weeks. At one point, about 5 to 7 days after I began experiencing symptoms, I asked a nurse for medical assistance. She told me that I did not have a fever and sent me back to my cell. Within a week or 2, one of my cellmates became sick and started vomiting in our cell. I used the emergency assistance button to call an officer. Over the intercom, the officer told me that they would not come check on my cellmate unless he is passed out or bleeding. Those were the officer's exact words.
All right, let's start talking about what we can do about these situations. Meg, you were very involved post-Katrina. You're still a public defender, locating individuals who'd ridden out the storm in prisons and been evacuated, and seeking to get them out. Can you tell us a little bit about the legal aftermath of Katrina and efforts to get people released?
Yeah, sorry, I'm just trying to catch my breath after listening to that testimony. It's pretty moving. Yeah, so on August 29th, 2005, when the storm hit, there were 6,375 men, women, and children in Orleans Parish Prison. And yes, I do mean children. There were 14-year-old children in the prison there. And, you know, our population at that time was only 484,000 people. So that's a huge jail population for less than 500,000 people in a city. These people were not evacuated prior to the storm hitting. They were not evacuated prior to when the levees broke and the flooding began. So they were left in the jail. You know, you heard about people basically having to swim to safety. Some people, depending on what building they were in, had to jump into water from high places and roofs. They risked their lives to try to evacuate. And many of the people who worked in the jail, many of the deputies, their lives were also placed at risk because nobody was evacuated. So once everybody got out, as you heard, they were brought to different jails and prisons around the state. We have a lot of prisons in Louisiana, so there were plenty of places to take them. And you know, you heard they had gone without food and water and you know, just very basic needs for a long time. And I don't think that any of that really is in dispute from anyone's point of view historically. But I think what's important to remember is that, yeah, there was a hurricane, and yes, you know, the wind and the rain, those are forces of nature, but the flooding and the impact that Hurricane Katrina had on the jail and the people that were in the jail and the families of the people that were in the jail, there was nothing natural about it whatsoever. So first of all, why were there so many people in the jail, right? Why were there 14-year-old children in the prison? Why did the judges not implement any sort of emergency releases of people that were being held on nonviolent charges? They risked the lives of people who had come before them, and for what? They continued to set bonds on people that they knew people were too poor to pay. They continued to hold people in jail who were sentenced to these sentences where you get a choice of whether or not to pay like $300 or serve 180 days in jail. So there were people that were there who nobody could make any colorable argument that they were dangerous, and those people were left to die, just like the title of the panel. The city didn't implement any policies to slow down arrests. So the police were still continuing to arrest people right up until the minute that, you know, these emergency evacuations were ordered and everybody knew, like, oh, wow, this is the big one, it's coming. And they actually kept arresting people on things even after the city was evacuated and everything was shut down. So nobody in the city had the forethought to take the initiative to say, let's make some choices here and let's prioritize public safety. And so that doesn't just put the people who are arrested at risk, right? That places the rest of their families, because we know that people operate in family units, right? And people need each other during times of crisis to take care of each other. So you're putting children, sometimes elderly people for whom the person that was arrested was the sole caretaker. And you're also putting the police and the deputies and everybody else at risk when you make choices like that. And I just have to keep reiterating that theme here. There were choices that were made by people in charge that resulted in a lot of the chaos that we saw. Now, one of the biggest players in that, right, was Sheriff Gusman. Sheriff Gusman is still our sheriff. He was the sheriff in New Orleans at the time of the storm. The Department of Corrections had offered Sheriff Gusman opportunities and places to relocate people that were in his prison to higher ground. And he rejected those offers, and specifically and infamously, as many people in New Orleans will remember, said, we're going to keep our prisoners where they belong. So everybody went about the whole thing business as usual, and kind of everybody that was in the jail was sort of an afterthought. So they didn't really try to make any changes or take into consideration anything that happened there. So sometimes when people try to frame Katrina or frame this issue as a natural disaster, it's really frustrating to me, because I don't think that's what we have here. And I have a feeling Brendon's probably going to echo that with a lot of the response to COVID, that there are things that are beyond our control, but there are things that are within our control, and people did not act responsibly. So when all this happened, I was baby, brand new lawyer. In fact, I wasn't even barred. And I went to a house in Alexandria, where I met you, Malia. And I stayed at the house with several volunteer lawyers. And I met probably the most heroic lawyer I have ever met in my life, and that's Phyllis Mann. And she is forever kind of my idol. But she put everybody up, and she put everybody to work. Phyllis had learned that there were some people who had been evacuated from New Orleans in the jail in Alexandria where she worked. And so when she was there to visit her clients, she was hearing from people, both people that worked at the jail and from her clients, like, hey, they got all these guys from New Orleans in here. And then so then she started digging, and she kept digging. And eventually what we did was we started this sort of crazy process of filing for the release of people. So the very first one was in Alexandria, and it was filed on behalf of people who were actually in jail, for the majority of them, for municipal charges. And a municipal charge is like an infraction, really. You know, it's an obstruction of public passage, disturbing the peace, something like that. Possession of marijuana, so like having a joint, which is a misdemeanor, that was actually one of the more serious charges that we saw during that initial habeas petition. So we went and had a hearing, and we were able to secure the release of some of these people, some of whom hadn't even been before a judge, some of whom had already served their time, and many of whom were in jail for just very minor charges. Actually, I think all of them were in jail for very minor charges. And so that was kind of exciting for about 5 minutes, until we realized that there were thousands of people in that situation, and that this was going to be a hell of a process. So we kept it up. And we had a team of volunteer lawyers who became these kind of ad hoc public defenders, really, because while we were able to get a list of the people that were in the jail, we didn't know where they were. They kept moving people around all over the state. We didn't know really anything about their cases. We certainly didn't know anything about them as individual people. And we were not even assigned to represent these people. So we kind of started representing people just en masse, right? So like, you're in jail, you can't get out, I guess you're our people. And you know, we weren't getting paid for doing any of this work either. So we kept that up. We were the only people that could collect calls. And so that was for the whole state. And keep in mind that there was Katrina, and then there were 2 other hurricanes. So it was very chaotic, being sort of like the clearinghouse of information for everybody. And not only was there not court and no lawyers, but even if you had the money to post the bond, which, I mean, let's be honest, if you had the money to post a bond, you would have done posted your bond, because you wouldn't want to be in that situation, right? Nobody's like just being cheap when they don't post their bond. But you couldn't have posted your bond because there wasn't anywhere to post a bond, right? Everything was shut down. It actually got to the point where one of the lawyers that I worked with ended up filing a motion with the Supreme Court of Louisiana, and the motion was titled, and I am not joking, Motion to Open Court, because the Louisiana Supreme Court wasn't hearing any of our motions. So one could argue that habeas corpus wasn't suspended, but I don't really know how you could make that argument with a straight face. So, you know, this is when we proceeded to continue this process of working to get people out, and it continued on for a really long time. And the ACLU's report from that time, from 2006, the Abandon and Abuse, can give you a lot of detailed information about everything that happened, a lot of context and a lot of detail. It's a great report. I don't love reading it because it's really painful, and it's very sad, and I think it's very frustrating that so many of the things that were in place at that time are still in place, and some of the people who made those neglectful decisions still have power. But today, I would like to just focus a little bit more on the positive. Katrina was 15 years ago, and I think that we've learned a lot as a community from that, and I think that there's definitely a lot of opportunity when the system is, you know, sort of cracked open like that, to be honest, and to fight to change things. And I think it's a lot harder sometimes for people that are in support of the status quo or just afraid of change to really argue against change, because it's clear that things aren't working. So,
Meg.
sorry?
No, go ahead.
So since then, I mean, I'm just trying to think of all of the actually really good things that have happened in Louisiana that sort of grew out of this. And I think one of the most obvious ones is our public defense system. Our public defense system is still chronically underfunded. I can't underscore that enough. I will continue to shout that from the mountaintops, but it is much improved. And that legislation that created a different system of public defense delivery was born specifically out of Katrina and born specifically out of this disaster where people weren't able to figure out who their lawyers were or keep track, or their lawyers weren't able to keep track of them because we relied on this sort of part-time kind of weird system of public defense. And so that there's definitely been a huge push there towards training, oversight, and having a centralized public defender board to oversee the delivery of their services. We also have in New Orleans a dedicated juvenile defense office, and there also has been a lot of reform in the juvenile area, and I believe a lot of it really stems from this time because of the terrible things that happened to the children that were evacuated in the storm. We don't have 14-year-olds in our jail with adults in New Orleans anymore. The jail is still a jail, so that's not great, but the population is way down. And the community has really put a lot of pressure on keeping that population down, on keeping the jail size down, on not continuing to build these like behemoth jails. I think somebody called it, I don't know, like a Gulag archipelago, whatever, but a giant jail. There's been a lot of community pressure to redirect money that we spend incarcerating people to things that actually serve the community. Our local public defender's office, where I work, if I can brag, the lawyers there are trained, they're well supervised, they fight like hell for their clients, they fight like hell for reforms in the criminal justice system, statewide and locally. And the city has also developed a fast track process, which means that a lot of the people that are booked on some of these pettier charges are released automatically. What else? So recently we were able to convince the legislature to give us $7 million additional dollars in an appropriation for public defense. Still not enough. Still got to keep saying that, but it was something, and it was a recognition of the importance of public defense and some of the changes that need to happen. And then most recently in New Orleans, we were able to pass a parity ordinance. And I think that, first of all, that's huge because it's not a thing that exists very many places, if anywhere. But I also think that it does tie into a lot of the lessons that we learned about Katrina, because I think that people are starting to understand that a public defender represents a client, right? And they represent the fulfillment of the Sixth Amendment, but they also contribute a lot to the larger community, to the health of the larger community, and serve as, watchdogs over government. And yeah, so I feel like it was definitely a value statement by that city council.
That's great.
Yeah.
I want to bring it forward to COVID and kind of kick it over to Brendon, who being out in California did not experience Katrina. And so I don't know if you have, other fire crises and other crises that you've experienced in your public defender office, but I'd like to focus on COVID and talk a little bit about your efforts and how they kind of relate. I mean, Meg talked a lot about trying to adjust or think about adjusting arrest policies, think about emergency releases in response to crises. So, Brendon?
Sure. So first off, say thank you for having me. This is a great conversation. So I guess as we all know, at least in my 25 years almost as a public defender, I have never seen anything the likes of COVID, where our whole court system is shut down, where speedy trial rights have been eviscerated, where people are being held in custody for extreme long amounts of time just because of a pandemic. I've never seen anything like that before. So figuring out how to deal with that was extremely difficult at first. And I'm just going to talk to you about how we focused it here, how we, I guess, began, almost have to keep your head on a swivel, because we started with our jail releases. Then it was like, oh my God, what's happening in a prison? Then, oh my God, what's happening in ICE? And it was like nonstop trying to work on COVID releases and trying to get ahead or keep pace with this pandemic. So I guess for some background, in Alameda County, we have a jail called Santa Rita Jail. And it's the third largest jail in the nation. I mean, third largest jail in California, the fifth largest jail in the nation, and holds up to about 4,000 people. It is an absolute monster. And it also has some of the highest in custody deaths for a county jail in California. And it's currently the recipient of multiple lawsuits. And as most jails, our jail, many of the people who are there in custody are held pretrial. And so in early March, once we began to realize that COVID was going to be COVID, and we had people incarcerated who were going to die if they didn't take action, we began to move quickly. Fortunately, here we have a monthly meeting with the presiding judge, chief probation, executive judge, my office, prosecutor, and we talk about issues as they come up. So in the middle of March, I sent them a letter with specific demands as they related to COVID. The letter asked for that the court release anyone who was over to the age of 50, and that they release anyone who had any sort of underlying health conditions. They release all people who had 6 months left to serve, release all clients with misdemeanor convictions or, pending misdemeanor charges or non-serious felonies, release anyone who was held on a technical felony or misdemeanor probation violation, and then had a policy in there to encourage all police departments to cite and release all low-level misdemeanor offenses. So we had a lot of ask, and surprisingly, at first they granted quite a bit of our ask. They started to begin to work on a policy for cite and release for misdemeanor offenses. They agreed to release anyone who had 45 days left to serve, and they began to work on releasing the vulnerable population based on age and physical capacity. So in about a week, we were able to reduce our jail population by over 300. And that was great. We were excited, but we still realized there was a lot more to do. And when we did those releases at first, there was a lot of media around, a lot of press coverage. And once those releases were done, everything kind of grinded to a halt for about 3 to 4 weeks. There was no movement on more releases about age or physical condition. They did not agree to release people with 60 days left to serve or more. They said they were working on it, but nothing really happened. And so for about 4 weeks, the court really agreed to release about 4 people based on our request. So there was really a standstill. And then April 4th was when we had our first positive person in our jail, our first person test positive. And that's when we began to say, we have to get moving again. We have to do something. And at our next Justice Partners meeting, or I call it more Justice Stakeholders, I spoke to the group and I was essentially begging, saying, COVID has hit our jail now. You cannot contain COVID in a jail. It will spread, people will get sick, and people will die. And I'm now begging you to increase releases, to move your standard up to 6 months or less. And I was literally begging this group. And on the other end was crickets. It was just silence. We're in a Zoom meeting and there was no response. And so after that, I was like, well, F this. We had to take some more action. And so we issued a press statement, a release about what the court and prosecutor was not doing. And we had this pretty intense back and forth in the media, but a few days after that, they began to release more people. And then a few days after that, our court implemented what we called zero bail, which was a modified bail schedule. Anyone with misdemeanors and low-level felonies were set at zero bail, they could be released. And so after that, our population was reduced tremendously. We ended up getting our jail population down to reduced by about 35%. We went from a population of 2,600 to about 1,800. And so we were happy with that. And then all of a sudden, in May, beginning of June, this outbreak happened in San Quentin. So I visit San Quentin prison frequently, and I have a lot of people there who I talk to. And in May, I received a letter from someone who was incarcerated. And I got it, I have the letter right here. I got it at first, and you can see how many pages it was. And I was like, Carrie, why the hell are you writing me this long ass letter right now? I mean, I got work to do. And then I was going through the letter and I looked at it. And when I got to page 3, it was signatures and signatures and signatures and signatures. And I can keep going. I mean, of people who were in custody in prison in San Quentin, nervous and terrified about what was going to happen. So that letter contained almost 300 signatures of people in prison. And they were concerned because CDCR, our state prison system, had made a decision to transport people from another prison that had been infected in Chino, California, to San Quentin. And, the gentleman here wrote me the letter, is like, Mr. Woods, you have to do something. This transfer is going to happen, and we're going to get sick and die. And so I had that letter. I modified it. I sent the letter to the governor, and I included those signatures. And of course, I got no response. That was in early June. By June 24th, June 3rd, June 1st, they had their first positive person in San Quentin. By June 24th, they had over 800 people that were positive in San Quentin. So then we took more action. There is a great, and one thing about us, we're very fortunate in the Bay Area, have a lot of really active and local community groups like the Ella Baker Center, Restore Justice on Common Law, and we all kind of banded together and held protests and did action items and really tried to put a lot of pressure on the governor and the Secretary of Prisons to get them to reduce the population. It resulted in a few releases, but not enough. And finally, we were able, I'm going on for a while here, we were able to get the Senate to hold a special hearing with regards to the danger what's been happening in San Quentin. Prior to that meeting, I started a petition, and over the course of 4 days, we were able to get about 10,000 signatures to give to the governor, asking for 3 simple demands: that they release everyone with a year left to serve, they release everyone over 60, and develop a robust parole process to release people immediately with 3 years left to serve. So that was our suggestions. They didn't follow them. They came back with something else that did result in about 8,000 people getting released, but nowhere near enough. It's only about 6% of our prison population was released. So when it came to San Quentin specifically, since we started our action, over 2,600 people were infected in San Quentin. Sorry, 2,300. Over 60% of the population, and we had 26 deaths. And when we talked about something that was preventable, that was completely preventable. If we talk about how we need to re-envision and rethink about how we look at safety and justice, that's a prime example there. And when someone who's writing me from prison is saying, Mr. Woods, the action that the Secretary of CDCR, Secretary of Prison is going to take is going to end up in people dying, it's like, God damn, why don't we just listen to the people who know what's happening, right? Listen to the people who are close to the problem, listen to the people who are incarcerated. So that's kind of what the situation is here. And based on that, I guess to follow up, we've been part of an action to file a writ of habeas in Marin County, joined by other public defender offices and primarily one other attorney, to bring an action to get people released. It's still being heard. It hasn't been quite successful yet, but we've done as much as we can to put pressure on the prison system to at least report what's been happening in our jails to release people. So I know I've went on kind of long there, Malia, so you can ask any more questions.
No, well, one question is, habeas the primary vehicle you all have been using? And, is a kind of a follow-up, when you asked for these kind of big condition release, like everyone who's got a year left to serve, in a lot of places, the pushback is we don't have the authority to do that, right? You have to go, you'd have to seek a sentencing modification from the individual judge. I feel like a lot of what happens in these situations is that we get stuck in the kind of individual versus collective action, and what's possible and who actually has the authority to do what. So can you just say a little bit about the mechanisms that you've used at the point at which you've been successful?
So I think going back to the county jail mechanism, by court orders where we got most of our releases, it was agreement between the DA's office and the court. And we were able to, by court order, I think the total was about 500 people were released. And then after that, getting the court to modify the bail schedule was the next biggest piece. And getting cooperation from the prosecutor and sheriff to, they couldn't direct, but request all the local police agencies to cite and release for low-level offenses. Those were our biggest areas. And I guess most of our success has come from mostly court order or order from CDCR, the Secretary of Prisons, as opposed to litigation in court. We've been, our most releases have come that way. And it's mostly public pressure and political pressure. Been most successful. And when it came to prison releases, it was all from CDCR, and they did modify to do a release program, which didn't come close to what we requested, but it was better. So the Secretary of CDCR did policy to release people with 6 months left to serve, but they excluded people who were violent felonies, anyone with a 290, which is sex registration, and there was one other category they excluded from. They also did a year left to serve releases, but they only focused on prisons that were positive for COVID, had high positive numbers. So if you're in a prison that did not have high positive numbers, you were stuck serving your year. And they also had a weird age requirement. Anyone who was 30 or over qualified for the release. If you were under 30, it was a case-by-case analysis. So they had some really weird carve-outs in there, but mostly it's been through order from either the court or from the secretary.
Okay. Eric, I want to turn it over to you as someone who's been at the National Prison Project since before Katrina and worked on cases both related to Katrina and COVID. I'd love to kind of hear the overarching perspective of a prison reform litigator and at what point you come into the situation, how you interact with local folks like Brendon and Meg, and what else you think has been effective in the aftermath of crisis.
Sure. Thank you, Malia, for inviting me to this very important topic. I got involved with OPP when I took over a case called Hamilton, which was a federal class action civil rights lawsuit filed on behalf of the detainees at OPP in 1969. And that sclerotic case still existed when Katrina hit. As Meghan mentioned, everyone knew that there was a looming disaster at OPP before Katrina hit. And the sheriff, Marlon Gusman, advocated his responsibility to safeguard the lives and health of the prisoners and staff in his care. And in fact, I just want to raise a couple points. He in fact made the situation far worse. He not only said he was going to keep the prisoners where they belong, as Meghan said, he invited sheriffs from other parishes to send their prisoners to him to be housed at OPP. So OPP really was bursting at the seams at the time that Katrina hit. And not only did the sheriff refuse to participate, as Meghan mentioned, in the counterflow planning from the state. He had been invited multiple times. His representatives had not shown up to this planning to ensure there was a safe evacuation route in place for the prisoners at OPP. The city of New Orleans added to the problem, the parish did. Katrina led to the first, as far as I know, mandatory evacuation order for the city of New Orleans. The only population that was excluded from that order were the prisoners at OPP. So when OPP hit, again, I had taken over this Hamilton case a few months earlier and found myself with thousands of clients, not knowing where they were, what condition they were being held in. I'd been stonewalled by the sheriff shortly before the storm in terms of his evacuation plan, and the court had taken no action on a pending motion to hold a hearing, so there could be discussion with the court on the evacuation plan for OPP prisoners and staff. After the storm hit, we began to hear stories about what the people trapped at OPP had experienced, and what they'd experienced after they had been evacuated from the jail. And we treated this like lawyers would in Washington, D.C. We prepared subpoenas. We prepared motions. We were going to litigate this as if it were a normal case until I sat down and talked with Mary Howell, a local lawyer who had been incredibly helpful to our office in litigating the Hamilton case over the years. And Mary had to explain to us that there was no court system. There was no system of justice that was functioning in New Orleans after Katrina. And we then began to realize the scope of the problem we were facing. We ended up connecting with Phyllis Mann and with the lawyers who were trying to find out where the thousands of prisoners who had been held at OPT had been dispersed to. We found some of them had been sent as far away as federal holding facilities in Florida. We ended up filing a handful of motions before the court, including one to get into the facility, the now abandoned facility, so that we could gather evidence that would show that prisoners had been abandoned there, to show that they had, in their desperation, carved their way through jail cells and jail walls, set signal fires in order to let someone know that they remain trapped in the facility. I traveled down to Baton Rouge, where the court was then sitting, to have a hearing on these companion motions in the Hamilton case. That hearing lasted about 10 minutes. The judge asked the defendants if anyone had died and if everyone were safe. And when defendant's counsel said no one had died and everyone was safe, she denied the motions and closed the hearing. It was obvious to us that there was no hope of us realistically to get relief for our clients through the Hamilton case. And so we pivoted. We had sent out well over 2,000 questionnaires to our clients once, with the help of Phyllis Mann and her very large team, once we found out where they were housed. And we began receiving hundreds of responses. We eventually received responses from over 70% of the people we had sent questionnaires to, and they told a horrific tale of what they had been exposed to, the conditions they had endured, the way their lives had been put at risk, both at OPT, at Hunt, and at the other facilities to which they were dispersed. And we took that information, we submitted it to the court, but we also prepared a long-form report that Meghan mentioned called Abandoned and Abused. It was the first long-form report that the ACLU had done of this type, where we told the story of what these men, women, and children had experienced during and after Katrina, both prisoners and staff. Because we really did not see a viable path to reform through the litigation, we increased our work, our advocacy work with local advocates, and our focus turned to making sure that OPT could not be repopulated to the extent it was before the storm. We worked most closely with an umbrella organization called the OPT Reform Coalition, a group of activists and stakeholders throughout the parish who worked very hard to try to make sure that the damaged buildings from Katrina were not rebuilt so that Sheriff Gusman could recreate his prisoner empire. With that work, there was a criminal justice assessment that was sanctioned and paid for by Orleans Parish, which showed that the parish could safely reduce its population by well more than half, not reopen and reoccupy the damaged buildings, and do so at far less cost. And eventually, the council passed a series of resolutions and laws that did limit the size and reduce the size of OPT to where it got down to approximately 1,500 prisoners from when it was well in excess of 6,000 prisoners before the storm. We also got the Hamilton case dismissed. Again, it existed by that point, almost 40 years after its filing, as nothing more than a means by which the sheriff could immunize himself from liability. And through a dismissal without prejudice, we cleared the decks for there to be effective litigation brought regarding conditions at OPP. And in fact, there was a successful lawsuit that's still being litigated called Jones versus Gusman, in which the United States Department of Justice joined, and we were involved in the process of getting DOJ involved, getting the weight of the United States government behind the case, such that it could be successfully litigated, and there was a successful consent decree entered there. The COVID challenge is different in type and kind than Hamilton, but does echo in it. As with Katrina, we had some fair warning as an organization about the damage and the life-threatening conditions that would be created inside our prisons and jails through the COVID pandemic. And the ACLU as an organization decided to launch a coordinated campaign to represent prisoners, immigration detainees, and sentenced inmates in COVID litigation challenging unconstitutional conditions of confinement and the fact of confinement in prisons, jails, and immigration detention facilities around the country. To date, the ACLU, that's the national office of the ACLU, along with the affiliates of the ACLU, have brought 129 lawsuits challenging conditions and the fact of confinement around the country. 73 of those cases are challenges brought on behalf of pretrial detainees and sentenced inmates in prisons and jails, and 56 of those challenges are on behalf of immigration detainees in detention facilities and jails around the country. I'm involved in 3 of those cases as counsel. One is a case involving conditions at the Broward County Jail in Fort Lauderdale, Florida. Another is a case on behalf of prisoners at the Maricopa County Jail in Phoenix, Arizona. And the last is on behalf of prisoners at the LA County Jail, which is the largest correctional facility in the country. We've seen the same type of initial reaction to the COVID pandemic in these and other facilities as was previously described. That is, there was an initial drop in populations. The courts were proactive in trying to quickly process cases through to release people either on their own recognizance or under terms. So they were moved out of an institutional setting, which created obvious risks. Those releases, in our experience, have leveled off. And in fact, if you look at the data now from around the country, the data shows that since about May, populations in at least jails have increased. And the Prison Policy Initiative put out a study where they looked at 668 jails. 71% of them had population increases from May to July of this year. So while things have somewhat leveled off, that trend is now being reversed in many facilities. In terms of the types of challenges that we are bringing, we're typically bringing, outside of the immigration detention context, class action lawsuits in federal court that combine both a federal civil rights claim, where we're seeking to ameliorate the conditions of confinement such that necessary protections to reduce the risk of contracting COVID, and then the risks once those prisoners contract COVID are reduced. We also are bringing federal habeas actions, asserting that the very fact of certain prisoners' confinement is unconstitutional. In those cases, we have focused upon subclasses of persons who are medically vulnerable, meeting various criteria of medical vulnerability, either by reason of their age or by reason of having a comorbid chronic condition that places them at significant risk of serious illness or death should they contract the virus. We have faced challenges in bringing these cases. I can't say that we've had a record of success that we can point to in these cases, again, outside of the immigration detention context. There are some hurdles that we have to traverse even to get to the merits. For the federal civil rights claims, we need to address an exhaustion requirement under the Prison Litigation Reform Act, which is a statute that was passed, signed into law by President Clinton in 1996, which prohibits prisoners from bringing a federal lawsuit unless they've exhausted the available grievance process at a particular prison or jail. In the cases that we've litigated, we have lost some cases on exhaustion, but we've won many more than we have lost. So that has not proved to be a hurdle that we simply have not been able to get over. For the habeas claims, in order to bring a federal habeas case, we have to demonstrate that we've exhausted state habeas claims or make an argument that the state habeas exhaustion requirement should be waived. And again, this has not proved to be an insurmountable hurdle. We have lost some habeas cases on those grounds. The most difficult hurdle we have faced is the deliberate indifference standard under which we have to litigate our claims. The deliberate indifference standard under the 8th and 14th Amendment is a very difficult standard to meet. It's a standard that, at least for persons who are sentenced, requires that one demonstrate that the prison officials have acted or failed to act with a conscious disregard of risk. And the problem we have faced is that prison and jail officials have done some things. They have taken some steps, and courts have been reluctant to hold those officials as being deliberately indifferent, regardless of how ineffective those steps are. Now, I should say that we have been litigating these cases in the context of bringing temporary restraining orders, preliminary injunctions, where we have not had the full opportunity to develop our factual record. And it's in that context that we have not been uniformly successful. In some cases where we have been successful, we have faced appeals that have overturned successful decisions. You may have read about the recent decision by the United States Supreme Court to, in fact, overrule the Ninth Circuit and grant a temporary stay to jail officials from the Orange County, California jail in a case called Alameda. And a very unusual step for the United States Supreme Court to intervene on a stay petition when the Ninth Circuit has already rejected it. So we do find ourselves, even in those cases, that we have prevailed in fighting uphill battles the entire way in order to secure relief for our clients. We've worked very closely, of course, with public defenders, with local advocates in this litigation. And one thing the ACLU is considering now is how we can assist in advocacy campaigns and efforts to not only ensure that any victories we cannot secure through court relief, we can secure through other means, but also thinking ahead to the fact that we do have reduced populations in many facilities, and how can we utilize that as a means to educate the public that county jails and state prisons be as large and heavily populated as they were before COVID. So that is sort of our next frontier that we're looking at in terms of the COVID and post-COVID work that we're doing.
Great. Thank you, Eric. I want to actually talk a little bit about one of the places that you ended, which is, you know, where court releases is not feasible and kind of other means of release. And I think you're talking about, you know, federal class action lawsuits not being viable as opposed to like potentially administrative orders. But, you know, are there programs that we should have in prisons to obtain, you know, whether it's a more invigorated compassionate release program you know, in these emergency situations, and what is it that you think those should look like?
Was that to me, Malia? I'm sorry.
It absolutely can be. Why don't you start?
Okay. Well, you know, again, this was mentioned that, you know, a big driver for at least the jail populations is people who can't afford bail. And so, you know, bail schedules should be, you know, bail should be, and bail schedules should be rethought or eliminated. You know, I can say, you know, for Los Angeles County, they instituted a zero bail schedule that was then adopted in slightly modified form throughout the state and led to significant reductions in jail populations. That schedule got lifted, but in Los Angeles County, it does remain. And so a big area here in terms of drivers for jail populations is people's inability to pay bail, and that should be reconsidered. Now, the alternative, so-called risk assessment tools, carry with them their own risks and their own problems. So there's not a clear answer or a clear alternative to bail, but no one should be held and jailed simply because they're too poor. We shouldn't have that two-tiered system of justice. That would be the first thing that comes to mind for me.
Brendon, Meg, if we stick with this pretrial detention piece, have you seen pretrial detention go down? Has that been a successful area of reform during COVID? And you know, do you think that is either sustainable beyond this emergency or something that you kind of know you'll be able to tap into in the event of the next emergency?
Yeah, so I mean, like what Eric was saying about like looking at the drivers of just like over incarceration in the first place, I mean, we can't forget that, right? And so it's not just about people that can't afford bond, it's about people that never maybe should have been arrested in the first place. Because when you're talking about COVID, even if you give everybody an ROR, right, like, and they don't have to pay a bond, they've still had to interact with a police officer, been in a police car, interact with booking staff, interacted with the other people in the jail, then they're coming back out and they're going.
I think Meg froze.
Jail in general. We want to do that anyway, right? Oh, I froze? Sorry.
Just for a second. Keep going.
Oh, okay. Oh, I was just gonna say, yeah. I mean, we want to just stop arresting people on petty nonsense, right? It's not really that complicated. It's like, you know, somebody's acting up, and you can just tell them, like, look, dude, like, chill, right? And then they chill. Why do we need to arrest them, right? So some of this stuff, it's like you can do all the studies and have legislative hearing and all this, but like it's actually really kind of common sense. And right now, our jail population in New Orleans, so remember what I said about the jail population being 6,375. Today, it's 864. And we are not a more dangerous community for that. And a lot of that definitely has to do with the fact that my colleagues, right? I mean, they busted their butts to get in there and make these arguments and keep pestering the court. And I think, you know, we learned to do that during Katrina. We learned that like when everything goes to hell, like you gotta speak up. You can't wait for the system to fix itself. But so I definitely think that is one way to work on addressing this. But I also think that, so here in Louisiana, the Department of Corrections did implement this kind of policy process, I don't know, where they were working to do releases of people like a medical furlough, right? And so the law in Louisiana permits the Department of Corrections to just furlough people, right? They have the legal authority to do that. And so they started this process and everybody was excited because they thought, okay, well, we really have the potential to address some of these things. And a lot of the people were people that were supposed to be out in 6 months. Some of the people who, you know, their paperwork was sort of already in the system and maybe they were, you know, up for a, you know, pardon or parole in any case. And so we thought, okay, here's a real opportunity. But it was a complete black box They wouldn't tell us who was on the panel. They wouldn't tell us who the process was. The weird like Venn diagram of all the things that you had to satisfy to even be considered was ridiculous. And the worst part about it, and I think this is something that needs to be consistent in anything where if we're being honest about what we're trying to do, or if we're just trying to pretend to do something, I think the difference is in whether or not you allow people access to counsel. So our lawyers, would talk to their clients and track them down, and they would prepare release plans, right? I mean, they would talk with clients' families and say, like, where can you go and live that's not maybe with grandma, because grandma is vulnerable and we don't want grandma to get sick. Can you have a job? Can we have some certain things in place? And can we share maybe some information about why you're not a dangerous person, or why you have some health issues that may make you more vulnerable? And we just sent these letters out kind of into like the ether, because nobody would ever respond to us or tell us who to even send them to. And so as a result, barely anybody got released. And so I understand that they were trying to put forth some idea that they were going to act under the goodness of their own heart. But I think as public defenders, we know that's never going to happen. So until you give people access to counsel and let their counsel actually do the work and advocate for them, like nothing's ever going to change. And so I think that I think a lot of times, like, people are nervous about dealing with lawyers and dealing with public defenders when they realize that actually, like, if you cooperated and worked together, you might find that the public defenders are going to do your work for you, right? They're going to help you make smarter decisions, and they're going to provide documentation and evidence to give you backup for making more pragmatic decisions.
Brendon, it sounded like you'd had a little more luck in terms of setting group criteria and potentially getting people out without requiring an individualized process. I guess I'm very aware of the fact that the individualized process, while good in the sense that it involves representation, it's individualized, can slow the whole piece down if you're trying to look at a jail of, I think you said 7,000 or 8,000 people, Santa Rita, and figure out who to release.
Yeah, so we were able to get around that, but when we got into more mid-level or serious crimes, that's when things slow down. There's always just a real fear of releasing people who have are violent or serious conviction on their record, or are in custody for a violent or serious conviction. That was also part of the problem when it came to the prison releases. And I was always very focused on that should not be their standard, especially when it comes to prison releases. A lot of the individuals who are in prison have served quite a long sentence already. And we know, at least in California, based on CDCR's risk assessment, half of our prison population were rated low risk, not a risk to reoffend, not a risk of harm to society. So right there, we know that those people should be released if we could release them. I want to touch back on another issue that was raised by Eric and Meg, the bail schedule and bail releases. So we've had zero bail put into place here in Alameda County also, and it's been really successful. And I think we, with all these releases that have occurred, I think, I hate to be a cynic or a pessimist, but we have to call it out that a lot of these releases probably would not have occurred if court staff and judges and sheriffs themselves weren't slightly concerned about getting the disease, or concerned about their staff getting the disease. I think, honestly, the people who they're least concerned about often are our clients. So I just want to put that out there as part of the reason why. And it was completely amazing to see almost overnight the amount of releases that we were able to obtain. And then with those releases, crime did not increase, crime decreased. And at least here in California, in Alameda County, when we went to zero bail, there'd be a few people who reoffended, and the press and the sheriff's offices and the agencies were all out highlighting those few cases. But this person went out and they committed 5 auto thefts in a row. They should be locked up. Zero bail is bad, blah, blah, blah. And they never talked about the thousands of people that were released and did not reoffend. So, for example, in Alameda County, when we went to zero bail, 94% of the people who were released did not reoffend. Our county next door, San Mateo County, I think they were at 97% did not reoffend. Santa Clara County next door, 91% didn't reoffend. This was all under zero bail. So this whole notion of the fact that we have to keep people in custody pretrial for safety is complete bullshit, okay? And we should call it that. And so right now in California, we're in a situation where we have Prop 25 is going to be on the ballot in November, and that's a bail reform. And yes, it's flawed. Yes, it has some crappy risk assessment, but it is, I believe, going to be better than the bail schedule we have now. At least I'm hopeful, fingers crossed. And we just saw during this pandemic how law enforcement just grasped on those few cases of people reoffending and went back to their old playbook of fear mongering. These are dangerous people. They're going to commit crimes, and your neighbor's not going to be safe, and blah, blah, blah. It's someone who might be running the goddamn country. But that's the rhetoric that's being put out there by law enforcement. And so we have an opportunity right now to really push back against that and create a system that is much more just for our clients. And finally, as Meg said earlier, there's no reason to be bringing people into custody and then releasing them, booking them, citing them out for these low-level offenses. There's just no reason. We have a real opportunity right now to reshape crime, reshape what we think is crime, and to look at it, as we've all said before, more of a public health issue. If someone's loitering, don't bring them to jail, right? If someone's having a mental health outbreak, don't bring them to jail. If someone's drunk in public, you shouldn't be brought to jail. Take them home. So we have a real chance right now to hopefully rethink, re-envision all of that. And we know as we start to do that, law enforcement's scared, right? Police agencies are scared. Jails are scared. Sheriffs are scared because underlying all this is economics and money. You build a jail that holds 4,000 people. They need the funding to keep that jail in place. And so I've gone on and on, so.
Well, no, I want to actually, so we've talked about low-level offenders. We've talked about, bail. I want to actually talk about two other populations. And the first one is one that Meg mentioned, which are juveniles. They've gotten a little less press even with COVID, but the fact that there are juveniles in lockdown, the fact that there are juveniles who, they've shut down visitation. So you have juveniles in detention who haven't seen their family now in months. Is this a moment, Brandon, you said this is a moment where we can push for low-level offenders better. Is it also a moment where we can push for reform for juveniles in particular, to stop putting these kids in detention?
Yeah. I mean, yes, the answer is yes. But I mean, the whole rationale, right? The whole legal basis for removing children from their homes and putting them in facilities is meant to be rehabilitative. So if you're risking their lives, you're not being rehabilitative. I mean, it's supposed to be, kind of a parens patriae theory, right? So the state is a really bad parent. State should not be in the parenting business, right? Because they're terrible parents. And any parent, that would intentionally, if they had the ability, right, to protect their children from COVID, they would. And so there's really no reason to keep kids in those kind of facilities where we know social distancing is impossible. And then I think once you, just like with everything that we're saying here, once you realize that there is a way to do something differently to solve a problem like a hurricane or solve a problem like COVID, and then you figure that out, you realize like, oh, wait, maybe there isn't anything, inherently logical or just about the way that we do things. I think all of these situations are kind of like people who aren't affected by the system may say, if it's not broke, don't fix it. Well, it's broke, right? And so now you can't argue that because it's really obvious. And so I think like that is sort of the opportunity here. Like we've gotten our jail population down to 864 people. Like it doesn't need to be any bigger than that. And in fact, it should probably be smaller. But yeah, I mean, I think that the juvenile, I was actually quite disappointed. I don't work with kids anymore, but it's my appreciation that there wasn't any real movement or real effort to try to get kids out of the system. There were kids that were sick, and the kids were scared, right? I mean, these are children after all. So the fear of getting sick, the fear of not understanding what's happening, you know, and misinformation that probably goes back and forth between kids because they're kids, right? You know, of maybe treating each other a certain way, right? Whatever, like that's traumatizing and it's unnecessary. And I don't really understand how anyone could argue that putting a child through that is going to make them, you know, a better neighbor or worker or family member or person once they're released. I mean, it's just, it's not that complicated.
Brendon, has there been movement in terms of release of the juvenile side in California because of COVID? And I mean, I know there's been a longstanding reform movement at juvenile. Do you think this will move that forward?
Yeah, there's been movement, but not enough. I know even prior to COVID, there's been lots of talks about closing out juvenile halls. For example, San Francisco passed a resolution to close their juvenile hall. There have been discussions in Alameda County. I'm not sure we're going to get there, but there's already been a movement around that. I don't think that we did enough on the release of juveniles here in California. And I think partly because our juvenile population was already so low as far as the custodial population. But one thing that is stark that needs to be called out when you look at our juvenile population that's incarcerated, I think that's where we run into the biggest racial disparities. It is completely off the charts. We've had times where almost, I think, close to 80 to 85% of our juvenile population we had in custody were black kids, or the amount of black kids that were being charged as adults in our county was extremely high, close to 99%. And so those are where I see the disparities being most stark. And I think we have to focus on that also. So as we have COVID ripping through our communities, we know that COVID is infecting and killing people of color at a higher rate. And then we have people who are incarcerated who are predominantly black and brown people. Then we have black and brown children who are incarcerated at a higher rate. So it all just snowballs. But to answer your question, yes, there is an opportunity to make some reform there. I don't think we've done enough or focused enough on that in California. I think partially because our numbers are already coming down. And then we get into that more vigorous discussion and battle, like, well, he's in charge, he's in custody with a robbery, with a gun, and this and that. And those more serious cases are harder to get things out of.
Yeah. You mentioned racial disparities with regard to juveniles, but obviously that's true throughout the system. And I worry when it comes to releases that those racial disparities persist, particularly when the vehicle for release is not across the board, right? If you're releasing everyone with 6 months left on the sentence, at least you have no opportunity to worsen racial disparities by applying that. I mean, other than the sentencing that already went into it. But in these individual applications, compassionate release, we're seeing that racial disparities are worse in how those individual decisions are being applied. You know, have you seen that in the releases that you've been able to effectuate, particularly when they are individual? And then that I want to give everybody, including Eric, an opportunity to respond to that and how we potentially fight back against that. And then I want to turn, we've got our first audience question. I want to make sure that we have an opportunity to answer some of those. So before I turn it over to people to respond on racial disparities, please, if you have a question, put it in the Q&A now.
So I think there are racial disparities. We haven't tracked that, but I think where it comes down, or where it presents itself in the biggest way is in the charging. Because we know statistically black and brown people are charged or get charged with more serious charges than their white counterparts. And that's where, when we're getting into the releases, even when they're, we could be doing group releases, 6 months after serve, that's still charged and they were convicted of, usually skews higher for people of color.
Meg?
So few people were released that way that, I mean, I don't even know like, I mean, I don't even know that how much the statistics would even really tell you. And in fact, you know, I think there's hopefully going to be a hearing, I think tomorrow actually in the legislature about this issue and what really took place. But yeah, I mean, it was such a tiny fraction of people. I don't actually have the percentages, how that broke down racially, but like I said, I mean, it was meaningless, the number of people that were released. So
Eric, is the ACLU looking at that in its release cases, and what are you seeing?
You know, we are. One thing that we're concerned about is, again, the extent that risk assessment tools will be used or have been used as a means of deciding who is appropriate for release. These tools, when they actually have been objectively studied, have shown a significant bias against defendants of color who present on the so-called objective criteria as having the same risk of reoffense or risk of plight. So thankfully, so far, most of the releases that have occurred in the cases that we've handled have been based, as Brendon says, on these objective criteria: someone's age, whether somebody has speech conditions. They've unfortunately gone by these bail schedules, but at least if the bail schedule is reduced to 0, it's just a matter of what offense, the incident offense, someone has been charged with. Our greater concern is the extent that jurisdictions will begin incorporating these risk assessment tools and making these assessments and determining who should be released.
Great. So from the audience, what mechanisms do you think cause correction agencies, whether state or local, to bring back the, quote, old way of operating, end quote, after tragedy or disaster such as Katrina, even after making significant strides forward? And how do we prevent that from happening? And Meg, I want to turn to you, because the truth is, since Katrina, the population is really down. So how did you combat that in a sufficient way?
Well, the community combats that, right? Like Eric said, OPPRC and other organizations are putting pressure on the city to not build a gigantic jail. Additionally, you pay public defenders a real salary, right? You have a good public defense system. Public defenders are there to defend the public from government overreach, right? So we represent our clients, and that is our first duty. But the fact of the matter is when you have a strong public defender office in your community is going to be safer, and the money from the taxpayers is going to be spent on things that actually help the taxpayers. So I do think that those two things are quite relevant. But as to what is the motivation to continue to do this, it's money. And it's great. And you heard from, you know, maybe I shouldn't say this, but whatever. It's like not really much of a secret. But you heard what Eric said about, I want to make sure this isn't lost in the conversation, but about how Sheriff Gusman actually offered to house other people during a storm when he knew that there was a terrible storm coming that was, you know, going to decimate our city. And no, we didn't know it was going to be that bad, but we knew that it was going to be bad. And he decided that that would be a good time to invite other people in. That's not an act of like Christian charity, right? You get paid per person that's in your jail. And so I think that is part of the motivation for why we want to build bigger jails. And additionally, right, I mean, I think all of this stuff, you know, and I think this isn't unique to Louisiana, but I think it's consistent to Louisiana, is that you've got to take money out of the equation. Anytime you have money influencing the way any decisions are made in the criminal justice system, you're going to perpetuate a racist, classist, tyrannical system. So that starts with bond. That starts with funding things based on fines and fees. That starts with public defenders, courts, you know, anybody being funded by money that's extracted from poor people and primarily from communities of color. That's what we do. That's what the system is. I think most of the people that are watching this know the deal, right? Yeah, so, you know, money should not be relevant to anything. Anytime money is involved, everything is a political decision. And the final thing, which may seem far afield, but I really don't think it is, you should never disenfranchise people because they have a conviction, because that makes decisions about who to prosecute and how to prosecute political decisions. When a person that is an elected official can take away somebody else's right to vote, we are not living in a free country. So
I don't know if Brendon has anything to add. No.
All
Sorry,
done. Done.
y'all got me riled up.
No.
Done. That's mic drop. Out.
Yeah. So there is one other question from the audience, because I would actually love to end it there, but I actually want to address it. This is not a population that we've actually addressed, which is clients with mental illness who are incarcerated during these times of incredible stress and the exacerbation of that mental illness, but also the possibility that those who are over detained are disproportionately people who are suffering because they're unaware of any error in their release. Can you talk a little bit about that population during crisis, either Katrina or COVID?
I'll just go real quickly. During COVID, a very vulnerable population, but also very hard for us to get out of custody and also place at the same time. In the very beginning of COVID, a lot of our court operations were restricted and shut down drastically, including the mental health court. And then we had service providers who weren't really up and running, able to take our clients. So it's very difficult. We're opening back up now, but at the beginning, extremely hard, extremely worried about when we were able to get mentally ill clients out of custody, making sure they were going to return to court, how they were going to return to court. It was very, very difficult in so many ways. I don't have a great solution or answer to it right now. One of the things is that as we open back up, we're able to provide them the service we were providing before, but it's been a very hard issue for us.
Meg, did you want to add anything, or Eric?
I mean,
I would add.
yeah. So
Go ahead, Eric.
Yeah, I would add that the particular challenges for this population is that persons with mental health disabilities or mental illness, there's a high incidence of homelessness and not having stable housing. And unfortunately, there'll be a significant reluctance in systems to release persons who don't have a stable housing plan. So one thing that we have sought in our litigation as part of the remedy was to ensure that the infrastructure were put into place for a housing plan for persons who were released, who did not have stable housing. And again, that would have a significant overrepresentation among persons with mental health disabilities. Looking forward, again, this COVID pandemic might provide an opportunity for reforms regarding persons with mental health disabilities. You know, the cost of providing someone with mental illness with assertive community treatment, that's treatment through their homes and in their homes, and with supportive housing, is about half the cost of jailing them. And with this pandemic, we would like to see if we can create local campaigns that can educate the public as to these costs, as a means of also providing information and education on the human costs of housing these populations in jails. You know, sheriffs don't want to house people with serious mental illness. They would love it if there were a certain community treatment, infrastructure, and supportive housing, so they didn't have to take in jail persons with serious mental illness. So again, there might be an opportunity moving forward to have as partners sheriffs in this effort to expand those services so that those persons would no longer end up in jail.
Well, thank you for that. I think that's a positive note. I want to thank this incredible panel. I hope you enjoyed this webinar. And I want to thank our co-sponsors again, for a very long time. This, as Meg actually mentioned, this has been very close to my heart. I think that this is a very important milestone to look back and ask ourselves, how far have we come and how can we push this farther, particularly in light of the crisis that we're facing today. I thank you for taking an hour and a half out of your day to make it important to you, and thank our panelists for their incredible work. And we will see you next time.